There is Senate Bill 1716. Representative Harris, read the bill, Mr. Clerk.
Law, third reading of this Senate bill.
We have before us today the Illinois Religious Freedom, Protection, and Civil Unions Act. As our country has evolved over the generations, once in every generation, legislatures across the country have a chance to advance the cause of liberty and justice for all as envisioned by the founders of this country. We have a chance today to make Illinois a more fair state, a more just state, and a state which treats all of its citizens equally under the law. As the Chicago Tribune said in its recent editorial, this is a fair step. This is a remarkable step for the state of Illinois. We have a chance here, as leaders have had in previous generations, to correct injustice and to move us down the path toward liberty. Years. Legislation that gave women the right to vote. Legislation that ended the anti-miscegenation laws. Laws that changed the tradition and law of this state and allowed interracial marriage. I just want to give you a sample of some of the arguments that were used of the proponents of those laws back then that have since been changed. In 1869, there was a woman in Chicago, Myra Bradwell. She was the first woman in the state of Illinois to ever apply for a law license. She passed the Illinois bar exam with honors and applied to the Illinois Supreme Court for her law license. They denied her application because she was a woman. This was the language that the court used as their reasoning back then to deny women a right to have an occupation outside the home. The civil law, as well as nature itself, has always recognized a wide difference in the respective spheres and the destinies of man and woman. Man is, or should be, woman's protector and defender. The natural and proper timidity and delicacy which belongs to the female sex unfits it for the many occupations of civil life. The Constitution of the Family Organization, which is founded in divine ordinance, as well as in the nature of things, indicates the domestic sphere as that which properly belongs to the domain and functions of womanhood. The harmony, not to say the identity, of interests and views which belong or should belong to the family institution is repugnant to the idea of a woman adopting an independent career from that of her husband. After that Supreme Court opinion was issued, 2 years later, this body changed the law of Illinois and allowed Ms. Bradwell to obtain a law license. Tradition had been changed and law had been changed, and progress had been made in this country. I'd like to read you some of the language that defined interracial marriage as counter to God's plan. The amalgamation of the races is not only unnatural, but is always productive of deplorable results. The purity of the public morals, the moral and physical development of both races, and the highest advancement of civilization all require that the races should be maintained distinctly separate, and the connections and alliances so unnatural should be prohibited by positive law and subject to no evasion. Ladies and gentlemen, for many years that had been the tradition of this country and had been the law of this country. But those traditions and that law changed, and I think we all believe they have changed for the better. Those who stood for justice, for fairness, and who cast the votes to change those laws and to change those traditions have been remembered by history as great leaders. They've been remembered by history as being on the right side of justice. Each of us in this chamber today have a chance to be remembered by history as being on the right side of justice. So let me tell you what this bill does, and let me tell you what it does not do. This bill creates a separate chapter in the Civil Code entitled Civil Unions. This law would establish civil unions which would offer the same basic benefits and obligations and responsibilities of marriage under state law, but specifically protecting the rights of religious institutions to define marriage as they choose and to practice their faith as they choose without interference by the state. The major benefits include hospital visitation, health care decision-making, disposition of a deceased loved one's remains, and probate rights. As I said, this law explicitly protects the rights of all religious institutions to either recognize or not recognize civil unions based on their faith and tradition. Civil unions would be available to same-sex or opposite-sex couples. It would be dissolved in the same manner as a divorce. They could not be entered into or gotten out of lightly. I want to tell you what the Civil Union Act does not do, because I think there's been some misinformation that has come around. This law does not create marriage for same-sex couples in the state of Illinois. As a matter of fact, the statutes of the state of Illinois clearly define marriage as between being one man and one woman. There is nothing in this law that changes the statutes of Illinois that separate marriage between, that make marriage between one man and one woman. This law does not allow partners to receive benefits under federal law, such as Social Security benefits or other benefits such as joint filing of federal tax returns. The important thing to recognize about this law is that it not only covers gay and lesbian couples, but the single largest, and I repeat, the single largest group of beneficiaries of this law in this state will probably be heterosexual senior citizens. Many of us spend a lot of time visiting our senior centers, going to community centers, talking to our seniors, hearing about the problems and issues our seniors face in their daily lives. And if you raise the issue, you will find many seniors in your district where they've been married to the same spouse for 30, 40, 50 years, but their original spouse has passed away. They're struggling to survive on a meager pension or Social Security income. Should they meet someone else later in life and wish to remarry, if they were to remarry that person, they would stand to lose those pension benefits or those Social Security benefits that allow them to live their lives in comfort. Taking a civil union would allow people to still enjoy those pension benefits, still enjoy those Social Security benefits, but would also allow them to participate in health care decision makings. It would allow them to share a nursing home room. It would allow them to help be the first in line to make the decisions about the disposition of their partner's remains when he or she dies. And it would allow them rights in probate. Public opinion on this issue has changed substantially over the years. You may have seen the Chicago Tribune polls, the Paul Simon Public Policy Institute polls, which have studied where people are in the state of Illinois on this issue over the last several months leading up to the election. An October 2010 poll by the Paul Simon Public Policy Institute of people who were considered likely Illinois voters in the November election showed that 67.5% of Illinois voters approved of either same-sex marriage or civil unions, 26.5% disapproved. An August 2010 Chicago Tribune poll showed that in Chicago and the collar counties, 54% of the voters support civil unions, 32% opposed. These are figures that are commensurate with the national trends. These are figures that are commensurate with studies taken in every region of Illinois. The Chicago Tribune, the Chicago Sun-Times, the Daily Herald, the State Journal-Register, the Southtown Star, the Oak Park Journal, the Northwest Herald, all have urged this body to do the right thing, to take a right step, and pass civil unions. Another question that I've heard relates to the cost to state employee benefit systems. If you'll look at the fiscal notes that are attached to this bill, you'll see that for the healthcare systems, CMS says that there will be a negligible cost. A lot of people don't remember back to the early days of the Blagojevich administration, but our previous governor did extend coverage to the same-sex partners of state workers access to our health care benefits as domestic partners. Those people are already on the system. There will not be a substantial increase should civil unions pass. You will also see a fiscal note showing on the website that the pension system for the state does not foresee a major impact on our pension costs, because the partners of same-sex couples would pay just as you pay for your spouse. They would pay for their spouse's contribution to the pension program and not the state. Where would Illinois fit within the spectrum of the United States of America on this issue? We would be in the broad middle. 5 states in the District of Columbia offer same-sex marriage: Connecticut, Massachusetts, Iowa, New Hampshire, and Vermont. Several states recognize marriage of same-sex couples performed elsewhere, which would be New York, Maryland, Rhode Island, and New Mexico. 5 other states have civil unions, such as we are proposing here: California, Nevada, New Jersey, Oregon, and Washington. People also raise the question of, can't people obtain these rights contractually by having documents drawn up by lawyers and getting these rights one at a time? And I guess that's possible if you can afford a lawyer, who understands all the intricacies of relationship law, of probate law. If you can have a document drawn up for every occasion that would be recognized by the appropriate authority and have it on you in the time of need. And there's probably no more poignant case of how this plays out than my predecessor, your late colleague, the late Representative Larry McKeon. And if you remember his testimony on this in committee after he had retired from this House, he told the story of how his partner of many, many years fell sick in the hospital, went into intensive care. He went to be by his side in his last minutes. The hospital turned Larry away. They said he did not have the proper documentation with him. They did not consider him next of kin. He would have to go home. He would have to go home and find the documents and return to the hospital with them. Ladies and gentlemen, Larry testified that he did return home. He returned to the hospital, and he had missed the passing of his life partner by mere minutes. By mere minutes. Should anyone have to be absent from the side of the person they most love in life because they don't have access to the proper paperwork at the right time? Should this not be a right that every person in Illinois be granted? Ladies and gentlemen, I know this is a controversial issue for many of you. For many who are to the left of me in my community, they say, why are you settling for second best? Why aren't you demanding that Illinois pass same-sex marriage? I understand that there's not the support for the change of the marriage law right now in the state of Illinois. To the right of me, I know there are people who would say, we don't believe that lesbian and gay couples should have any rights under the law in this state whatsoever, that they should be estranged from the law because of their sexual orientation. Ladies and gentlemen, this legislation is a fair moderate center. It does not change the definition of marriage. It provides basic legal rights to our citizens. It's a matter of fairness. It's a matter of respect. It's a matter of equality. I hope that each of you will join me today in being on the right side of history, and I hope you will vote yes on the Civil Union Bill. I would be happy to hear your comments and take questions.
The chair.